What's up, everybody? Welcome back to the VSO Gun Channel. It's great to be here as always, and thank you for watching. Today we're talking about the Texas Suppressor Freedom Law. This legislation has hit yet another snag. Another stop has got in its way, so to speak. And the reason I bring you this is because I think that it's really important that when we finally do successfully litigate this case, we as in the Second Amendment community, it's important to have a thorough understanding of where the potential stops could be so that when other states want to emulate this behavior, they know where they can go wrong. And I think we kind of all sort of knew where this was going. If you've been following this, like I have, then you kind of guessed where this was going to go. But for those of you who don't know what the heck it is that we're talking about, you all know that suppressors are highly regulated. You have to go through the NFA process, fingerprints, unconstitutional tax stamp, intrusive background check, et cetera, right? All for something that is not an arm, by the way, and therefore outside the jurisdiction of the ATF. But that's another discussion for another day. Texas said, hey, the reason that you have the power to regulate these things is it is granted to you through an act of Congress under the enumerated power of interstate commerce. The executive branch can dabble in regulation of interstate commerce. Well, Texas says, what about suppressors that are made in Texas, stay in Texas, are owned by Texas residents, and are made of materials 100% manufactured in Texas? That does not implicate interstate commerce whatsoever, so you do not have the jurisdiction. And so there are a couple individual plaintiffs in that one, and the state of Texas tried to step in as well. Well, this has been recently denied by the Fifth Circuit. So after we hear a quick word from today's sponsor, I'm going to tell you why it is that they were denied. We have 2 discount codes prepped up for you guys over at Mission First Tactical. One is for the all-day everything stuff, everything from their backpacks to their drinkware to the holsters to even the new translucent magazines that they just came out with. Really like the purple ones, by the way. And then a second code that is for everything that is getting ready to go away, like 50 or 60% off in many cases. So you can find all that information over at the affiliates page, and special thanks to Mission First Tactical for making today's video possible. The case in question is Paxton v. Diddleback, or as I like to call him, Diddle Boy. The way they're going about this is you can't just violate the NFA, right? Because you're going to go to jail. And the court here recognizes that you shouldn't do that, right? Especially when we're talking about potentially 10 years in prison for something like this, right? So they're trying to walk the line of pre-enforcement challenge, which basically says, hey, we recognize that you can't just go do this thing, because that would definitely grant you standing, but you'd also have to defend it from jail. So that's probably not the best way to go about actually trying to affect change here. The question is, do they have standing to do so? The individual plaintiffs have claimed that they established injury in fact through their signed, unsworn declarations, each of which stated in relevant part, I intend to personally manufacture a firearm suppressor for my own non-commercial personal use. The firearm suppressor will be manufactured in my home from basic materials without the inclusion of any part imported from another state other than a generic insignificant part, which is a spring, screw, nut, or pin. For 2 reasons, we find these declarations are insufficient to establish serious intention of engaging in conduct prescribed by law. First, the declarations do not state any intention to engage in conduct proscribed by law. Rather, the declarations state only that the individual plaintiffs intend to personally manufacture a firearm suppressor for their own non-commercial personal use. But as federal government points out, the statutes at issue do not prohibit the individual plaintiffs from making a firearm suppressor. Rather, they only prohibit making a firearm suppressor without complying with the applicable procedures and requirements. Applying for approval, paying the requisite tax, registering the suppressor, labeling it with the serial number. You get the idea. This is a distinction with an important difference because it differentiates the case from those in which the statutory scheme at issue is blanket prohibition. And then they give an example of carrying a handgun under the age of 21 and it's, being expressly prohibited. And then they say here, the opposite is true. The individual plaintiffs have only stated an intent to personally manufacture a firearm suppressor, but say nothing about whether they intend to personally manufacture a firearm suppressor without applying for government approval. And they make no claim that they are statutorily ineligible for such approval. So they have filed to show that their intended conduct is within the scope of what 26 USC blah, blah, blah prohibits, and therefore lack standing to bring their pre-enforcement challenge. So this may infuriate some of you, but to translate that, what the court said is, you said that you intend to do this, but you don't say that you intend to do it and violate the law doing it. Yeah, semantic difference. The whole point of the case is we don't want to have to fill out this paperwork. We don't think that it's the right thing to be doing, and therefore we don't intend to do that. They didn't expressly write that in their filing, so the court is dinging them on standing because they didn't say, yeah, we want to do this and we want to violate the federal law doing it. If you were in that situation, would you not be absolutely ticked off? Second, the declarations lack the necessary detail to establish that the individual plaintiff's professed intent to make a silencer is sufficiently serious to render their feared injury imminent rather than merely speculative or hypothetical. And then they give an example from the Montana Shooting Sports Association v. Holder case in the Ninth Circuit, where they established the proper types of things that you would put in to show that you're serious about this. So basically what the court is saying is, hey, you didn't say, I intend to do this and I want to do it like next week sometime. I have these materials that would allow me to do this. I purchased these tools specifically for the purpose, which walks the line, in my opinion, on the outside looking in, as constructive intent. So basically what the court is saying, you got to go buy the tube and you got to have the tools, but you can't have any of the other components, because if you do that, then you're definitely violating the law, right? So you got to walk the line. They didn't walk the line close enough. So is this case dead? I don't think so. Or at least if this is what my court told me, then I would not give up. I'd go right back to the drawing board. I'd take the same documents that I had already submitted and I would doctor them up and say, Your Honor, I intend to do this, and I intend to also violate the regulations in doing so. And to prove it to you, I have purchased this 8-foot length piece of pipe and the following tools, and I would like to get this accomplished sometime in the next 2 weeks. But because of this stupid regulation, I can't do that. And I am being injured from being able to exercise my otherwise constitutionally protected, God-given, and inalienable right. Let me know what you guys think about this in the comment section down below. Do you think your state, if Texas does this and gets it all the way through, do you think that your state will be one of the next ones that's like, oh, well, I guess we're going to have the Ohio Suppressor Freedom Law now? For the record, I think that this is complete and utter bullshit, and these judges wanted to punt so that somebody else would get drawn and they wouldn't have to actually be the people who made the decision on this one. Cowards. Shame. 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 Shame.